The time is 1:10. We're back from recess, and we're going to pick up with agenda item number 12, the Rulemaking Report.
Okay, so on page 85 of the meeting materials is the Rulemaking Report, and it is the tracking form that we developed from the 2019 rulemaking calendar that was adopted at the December 2018 meeting. The first two items on the rulemaking tracking form are the satisfactory documentary evidence of equivalent degree for licensure as a PT or PTA or coursework tool. And also the second item is setting the exam score. And both of these initial rulemaking packages, and those initial rulemaking packages include the initial statement of reasons, notice, proposed language, and the fiscal analysis form 399 are being prepared by staff and will be going to DCA for their review soon. And they'll be completing the new DCA process that was included in the materials. The next item on the tracking form is the disciplinary guidelines, and as we discussed at the previous meeting, these guidelines will need to be modified to implement the changes that were required by AB 2138. Some of those changes, those proposed changes, will be provided to you today, and we'll discuss those after we go over the rulemaking, the proposed language for the AB 2138 rulemaking. The clinical service requirement for foreign educated. Staff are preparing the initial rulemaking packages for completing the new process implemented by DCA. Those will be going to DCA for their review soon. The substantial relationship criteria, rehabilitation criteria for denial and reinstatement of licensure, and the rehabilitation criteria for suspension and revocations will all be presented proposed language under agenda items 12B, 12C, and 12D for board consideration today. And all other items on the rulemaking tracking form, we're still continuing to research, and we'll be bringing forth proposed language in the near future for board consideration.
Any board comment or questions? Anything from you, Mr. Kaiser?
No, I think there's some things that we'll have to address about the model guidelines, but that'll be subsequent to our discussions about the three new packages. So I'll reserve until we get to that point.
Okay. And any public comment on the rulemaking report? Okay. So,
are you going to do the, okay, so you did examination passing standards, and then you're going to skip over?
Well, we just went over where they are on the
just
report
did the
itself.
General,
yeah.
Okay. So the reason we're doing AB 2138 items first is that they actually impact the update regarding the guidelines. So makes sense to do it in that order. I think that Brooke did a wonderful job with her memos on the substantial relationship criteria, rehab criteria for denial and reinstatement of licensure, and rehab criteria for suspensions and revocations. And I think it lays it out really well. So, you know, what I'm prepared to do is take any questions if the board has any. Based on those memos, so we can just go through it one at a time, starting with the package relating to substantial relationship criteria.
is there a particular page that you're looking at?
Well, the memo is on
The memo, yeah, I've got that.
58 of the package, and then it's followed by the text, and there are two options there proposed for the board's review regarding substantial relationship criteria. and then it's followed by the bill, AB 2138, for your review. I guess I'll just point out one of the main differences between option 1 and option 2 is that option 2 has that subsection C there, and the subsection C gives examples of professional misconduct 1 through 9. And I think one of the main reasons that was included there is that that's how some boards have it. They have examples. And the second one only has that Part B, which has those actually required by AB 2138, 1, 2, and 3. But as you can see, there are the two options, and having those extra examples under subsection C aren't necessary, so you don't have to go that way. One thing to consider as to whether or not you want that subsection C, or one reason I think boards have been considering is that even though it uses language that says something like includes but are not limited to the following examples, I think some boards feel that by listing the examples it can feel limiting or feel like you have to go through all of those, and would just rather leave more discretion to the board to consider whatever additional factors they want without necessarily having a list. Because when you have a list, then it becomes, why are you including some things and not other things? But otherwise, I think the staff may have had a preference if they want to speak on that. But otherwise, I think the memo really does a great job if anyone has questions.
That including the C limits the ability to make a decision?
No, I don't think it does limit the board, because it does use that language, includes but is not limited to. It specifically says that. But I think, it becomes like a sense of like needing to go through all of the factors because they are listed there, whereas maybe sometimes you may want to consider some but not others, or you may want to consider some that aren't listed. It just simplifies the law a little bit to not have a list there. But I don't want that, that doesn't necessarily have to be the overriding consideration for the board. It's just one thing I've heard as maybe a consideration. But
There's a couple things that, that I would point out. One being, between the two options that we presented for each of these languages, we're coining the phrase that, the first option is kind of the discretionary model. It's also the most similar to our existing regulatory language for these three categories. That second model that we're kind of saying includes but is not limited to, and bullets these kind of things out, it's not a matter of that it limits you per se. In conversations that not just ECA and the boards have been having, but the Attorney General's office has been included too. If there are violations that automatically, without board discretion, would result in some kind of revocation, suspension, or denial, the AG's recommendation is to include that there. And in doing that, that list essentially means that person, if they commit that offense, could expect to have this happen to them. No point of discretion is going to be applied by the board. And I guess that's the limit kind of side of the argument that I'm concerned with, is that I would rather see this board exercise its discretion in considering rehabilitation and mediation and anything that somebody might bring to the table, regardless of the offense, and deliberate on that. By singling it out and by saying, we have kind of an example of that in our statutes, that if somebody has an offense of sexual misconduct against a minor and has found themselves on a list for Megan's Law, they're presumed disqualified from application for licensure, right? So that's a good example of what could be included on that secondary list of included but not
limited to.
That if there's something that pertains to your profession that just if they violate that particular law, a good one would be for the Board of Accountancy if there is a fiduciary crime of some kind, a fraud against a client. If you've committed that and been convicted of it, don't apply here again because you're not getting anything. If it's something that you're not willing to apply any discretion to, you could include it on that list. I like the simplicity of the first model better.
And I will say that when these two options were proposed, that second option, and I think I alluded to this when I first spoke, in that second option, that part C, where it says including but not limited to and has all of the examples, was not actually proposed text, for example, by the legal office. I think what we did is that we took two of the most common types of regulations among all of the boards and said, you know, for the two most common types of regulations we see, this is how you might want to tweak it to comply with AB 2138. For this other one, here's how you might tweak it to comply with AB 2138. For that option 2 that you're seeing, those examples listed in Part C are pre-existing regulatory language for other boards. So that wasn't something that was necessarily proposed for AB 2138. It doesn't. It's not.
It already exists.
It doesn't satisfy any new requirements of AB 2138. It's essentially it's extra because other boards already had it. So it's not something we're necessarily proposing. The first option, I think, kind of it reflects more of exactly what we're proposing in order to satisfy AB 2138, and that's that AB 2138 requires that you consider those 3 factors. For
Nature and gravity,
to
number of
determine
years.
substantial relationship criteria, yeah. So, but that second one, it's underlined for the board for that second option. Sorry, let me say that again. Part C, those examples are underlined as new text for the board because the board doesn't have it currently, not because it's necessarily recommended language to use. But it's put out there for you to see as an option, since that's how some other boards have it. It's not necessarily to satisfy AB 2138.
I agree with board staff that option 1, simplicity, lends to more of the board's discretion and allows us to take each occurrence on a case-by-case basis instead of boxing us into a set list that might be interpreted differently by different people. So I support option
1. I'll weigh in as well. I agree with Ms. Ellaby. I like the first option in that it gives us a little bit of latitude. And I know option 2 still has the phrase including but not limited to, but I think when you read this document from the consumer or practitioner side, you're sort of looking at these, okay, these are the things that I have to make sure I don't do, and everything else might be okay, when in fact it might not be okay. But I'm just, I guess for council, does this option sort of increase our level of supporting our decision? And I ask that because when you look at this sort of bullet list, it's sort of we don't really have any recourse here. It has to be, our action is, or our decision is based on you meeting these bullet points. So almost like deferring to just, that's what the law says, versus, do you know what I mean? Or in going with option 1, are we at a point where you have to justify each and every part of a decision that we render?
Well, your decisions, yes, have to have like a thorough analysis and all of that, but I don't think that this
doesn't increase or heighten that requirement.
No, I don't.
Okay. Yeah.
I think it clarifies what you need to review with regards to substantial relationship criteria, but I don't see it as heightening or changing the level of the burden on the board.
Yeah, I assume we're all in agreement. We're, making these decisions based on our best efforts at, adhering to the spirit of the law. Just wanted to make sure it wasn't going to be a clerical burden.
No, it's very much in alignment with the way the deliberations occur now.
Regarding the language, and actually in both options, in B, 2, the number of years elapsed, is there a particular requirement with, is it 1328?
2138?
2138, with using the word years or a number of years, or should it be, I'm wondering if maybe a more appropriate description would be the amount of time since the date of the last offense, because years might not be the right term.
I think that's the criteria that 2138 put out, was number of years.
Well, even those three, they're almost direct quotes from the bill language itself, where the board shall consider, and that's the language that's used,
Okay.
is the number of years.
And
But I understand there is that second reference to years as well when we're talking about that 7-year number and what can be considered and that kind of thing. But I think years doesn't necessarily box us into any kind of like time parameter or frame.
Okay. And then this next question with regard to number 3, which looks like it requires, it's going to require a decision on our
Yes.
part, whether we want to say the nature and duties of a licensee or the nature and duties of a physical therapist or physical therapist assistant. And I might actually say a licensed physical therapist or physical therapist assistant, just to complete that little bit of work before we move on.
You want to have it say the nature and duties of, and then remove licensee and say physical therapist.
Of a
Licensed.
licensed physical therapist or physical therapist assistant.
Yeah. So which one comes first, right? The consideration of A and B or the fine tuning of A?
Roberts would say that you fine tune A and then you fine tune B, and then you decide which of those you want to pursue. And then once you've decided which of A or B you want to pursue, you then have the final opportunity to further revise the last decision if you want to pursue Roberts. Seeing as we currently do not have a motion on the floor and a motion to substitute, then it's kind of a moot point, but that would be the exercise if you wanted to go down that road.
And when you say A or B, do you mean option 1 or option 2?
Yeah.
That would be correct.
Thank you.
Should we straw poll, Alicia, to see how people feel about option 1 and 2?
Yes, can we start with you, Ms. Ellaby?
Option 1.
Option 1 as well.
Option 1.
Option 1.
Option 1.
There you go.
So at that point, I would recommend no investment needed into option 2
Or further exercise.
or further exercise.
Okay. And there's some recommended verbiage for motions if anyone feels compelled to do so.
Well, the verbiage options are either as written, which I don't think that we can do in the first paragraph because of the way that number 3 reads, B3 reads. So I think that we have to decide how 3B and or any of the rest of it reads, and then go with the as amended language.
Thank you, Dr. Drummer. Let's do that. So, looking at option 1. Brooke, do you just want to read us through it, please?
Okay. 1399.20 substantial relationship criteria. A, for the purposes of denial, suspension, or revocation of a license pursuant to Section 141 or Division 1.5 commencing with Section 475 of the Code, a crime, professional misconduct, or act shall be considered to be substantially related to the qualifications, functions, or duties of a person holding a license under the Physical Therapy Practice Act if to a substantial degree it evidences present or potential unfitness of a person to perform the functions authorized by the license in a manner consistent with the public health, safety, or welfare. B, in making the substantial relationship determination required under subdivision A for a crime, the board shall consider the following criteria. 1, the nature and gravity of the offense. 2, the number of years elapsed since the date of the offense. And 3, the nature and duties of a licensed physical therapist or physical therapist assistant.
I will clarify, there were actually 3 examples that the board had, A, B, and C, that are crossed out, of what such crimes or acts would include. The option 2 off the table, but I did want to clarify because I misspoke earlier, had several of those same examples, but it had up to 9, whereas the board had 3.
Okay.
Just to clarify.
I like Dr. Drummer's recommended revision. It adds clarity.
Any other comments on that text that was just read?
We had the comment from Dr. Drummer about the wording of number 2. So while the wording of 1 and 2 are exact off of the statute, the wording of 3 is a little different, a little more verbose. It says the nature and duties of the profession in which the applicant seeks licensure or in which the licensee is licensed. And then it takes out any identification of any specific type of license. Just thought I'd throw that out there as to how the original statute is worded.
Sorry, and can you point out where is that?
In the original, it's actually in the statute or language that will take effect for Section 481. I'm looking at the California legislature's legislative information website, the bill text for 2138, which I think you actually have in your materials.
Do you have a section and paragraph?
Well, Section 481, but I don't know where.
In the prior page of the materials, at the very top, it lists it.
That's right, it's on page 70, yeah.
PDF 70?
Yes, actually. And also there's like a stamp in the bottom right corner that is 70. And then for the actual bill, it indicates a page 93.
Okay.
And it's section, future section, code 481. And you can see how that language was written into the reg.
And the language in the bill, to me, is very general, and because it's intending to apply across any of the licensed occupations, professions within the state. So I think that focusing it more towards the licensed population that we oversee would be appropriate.
Okay. Any further comments? Yeah.
I just had a question. Sorry, I was reading and rereading this. Are maybe for council, are we bound to the order of 1, 2, and 3 under B?
No, it's,
'Cause my comment was, in sort of rereading the text in A, it speaks to qualifications, functions, and duties of a person holding a license. So for me, if just for consideration here, it seems like we ought to be defining number 3 as number 1. So what is the nature and duties of a licensed physical therapist, and then what is the nature and gravity of the offense? Minor point, but it seems like that's kind of what we're talking about, establishing what the nature and duties of a licensed practitioner.
yeah, I don't think the order of 1, 2, and 3 carries any particular meaning in the sense that you're not
Yep.
that one is more important than the other, and it's not like a ranked system or anything like that.
Yep.
The only considerations I can think of why, of keeping them the way they are, and I'm not advocating, just some considerations for board's thought, is that when OAL, Office of Administrative Law, is reviewing the packages, uniformity, similarity between the packages they're looking at is always helpful, but at the same time, that's such a minor change that I don't think that necessarily could slow down the package, but just uniformity across the programs, or let me see if there's any other potential consideration. And uniformity with the statute itself, because that's how the statute is ordered. Those are the only 2 things I can really think of as to why you might want to keep it in that order, but I don't think either of those things are going to be detrimental to your package. It's, I think, more probably of a stylistic thing, or just making it a little bit that much easier on OAL.
Thank you.
Anyone else want to comment on that? Okay. Any other suggestions?
I could probably take that a little bit, like maybe one step further than Sawa, in that a lot of time was invested in trying to conform language as a result of that bill. And so what you see before you is a fairly well vetted idea of what the language should look like moving forward. And it will help, more importantly, the boards and bureaus through the process, but OAL be able to process multiple packages at one time. The bill is is such a significant change that, and it's under what we would call a pretty good time crunch too. So that bill takes effect. We'd like to have these regulations in effect as quickly as possible to meet up with it. So anything that we could do to shave off that time in the process, I would recommend it.
Mm-hmm.
So does changing number 3 to make it specific to our profession?
I think that's
anything?
to be expected.
Okay.
I think
Okay.
that's, even in the way the language is prepared here, where we've kind of filled in the blanks, you'll see similar presentations at other boards and bureaus doing very much the same thing.
Okay.
And I think actually number 3 was worded a little bit differently than kind of the uniform language that's gone around. The uniform language gone around, I think, had said the nature and duties of a, and then it says the license type. So in this case, it would be physical therapist or physical therapist assistant. And then in brackets, or the license type sought or held by the person. So that's another, that was the, I think, originally proposed language. So this is actually a little bit tweaked from that for number 3. So if you did want another option, I think that's another potential option.
I like Dr. Drummer's language. You guys all like Dr. Drummer's language?
Is there any worry or concern about additional license types that you want to leave the door open for? Like, I know in the PT Practice Act there was something about electromyography. I don't know that, that doesn't seem to be a used license type at
No,
this time.
so the electroneuromyography and the kinesiological electromyography are certifications applied to the parent license. So they're not necessarily separate license types. They're a specialty certification that's tacked on to an existing PT license, but whatever, I'll do it anyway. That initial language that comes from the statute that implies of a licensee seeking license in a given, that given profession, that even more general language to me might also relay to who is reading this, Code of Regulations under the Physical Therapy Practice Act's regulations, that this requirement is everywhere, right? When you go and you read it and it's within the Code of Regulations for PT, it's very easy to assume this applies to a physical therapist, but I wonder if that applies to an occupational therapist, or I wonder if that applies to a speech pathologist, or or something like that. And so, like I said, I'll just throw it out there for throwing it out there's sake, is that maybe general is better. Maybe that language that's actually included in the statute that says, or a licensee seeking licensure in the given profession, as close to that language as I could get, is better than actually calling out or a licensed physical therapist or physical therapist assistant.
But licensed PT and licensed PTA is the realm in which
Absolutely.
we operate.
Yep.
So I kind of follow your train of thought, but I don't know how it deviates from what our sphere
Purely
is.
for devil's advocate's sake.
Fine, thanks.
Yeah.
I think this is great because I think the idea is to have a conversation about all of your options, and that's, I think, a good opportunity to talk about what the Office of Administrative Law looks for, and that's clarity in your regulation, so that extent that you know the universe that you're operating in, you can make your regulations more clear and specific, better.
Mm-hmm.
Yeah. So I get that was what my question was geared towards: is do you think that by saying PT and PTA that would cause problems for the board for any reason in the future? But it doesn't sound like it, because those other items are certifications.
Right.
So long as it's not limiting the board in some problematic way,
Correct.
then the more specific language would probably be more ideal.
Okay, so you want to read the motion under option 1 in the second paragraph?
I move to approve the proposed regulatory text of option 1 as amended for section 3099.20. Direct staff to submit the text. Oh, great. Reminds me of making videos. I move to approve the proposed regulatory text of option 1 as amended for section 3099.20. Direct staff to submit the text to the Director of Consumer Affairs and the Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the Executive Officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing.
Okay.
And to clarify, the as amended piece is the changing the text to say
Licensed.
The nature and duties of a licensed physical therapist or physical therapist assistant.
thank you.
I second.
Motion by Mr. Watkinson, a second by Ms. McMillian. And any further board discussion? Any public comment? And a roll call vote, please.
Alicia Rabbeinu-Aman,
Aye.
TJ Watkins,
Aye.
Jesus Dominguez,
Aye.
Daniel Drummer,
Aye.
Katarina Ellaby,
Aye.
Tanya McMillian,
Aye.
6-0, motion carried.
Okay.
So the next two should go really quick.
Okay.
So for the the second one, is rehabilitation criteria in the context of denials and reinstatements. And again, the memo does a great job of laying out the background and talking about the two options. And so I won't rehash all of that, but if the board has any questions about those items, then I'm happy to try and answer those questions. I will point out that one of the main differences between option 1 and option 2 is that option 1 gives the board a little more discretion than option number 2. So option number 1 says that on the, I'll just read it. When considering the denial of a license under section 480 of the code or a petition for reinstatement under section 11522 of the government code on the ground that the applicant was convicted of a crime, the board shall consider whether the applicant made a showing of rehabilitation and is presently eligible for a license. If the applicant completed the criminal sentence at issue without a violation of parole or probation, in making this determination, the board shall consider the following criteria. So the board is obligated by AB 2138 to consider those criteria if someone was convicted of a crime. And then you go down, and there are 5 criteria, and then you go to B, and it says if subdivision A is applicable or the board determines the applicant did not make a showing of rehabilitation based on the criteria in A, the board shall apply the following criteria in evaluating an applicant's rehabilitation. The board shall find the applicant made a showing of rehabilitation as presently eligible for a license. If after considering the following criteria, the board finds the applicant is rehabilitated, and then it lays out that criteria. So it says the board can consider A, but if the board is not convinced of rehabilitation, then it can move on and it shall consider that following criteria. And then going to option 2, and option 2 is, I think, much more narrow. It says when considering the denial of a license under 480 of the code on the ground that the applicant was convicted of crime, the board shall find that the applicant made a showing of rehabilitation as presently eligible for license if the applicant completed the criminal sentence at issue without a violation of parole or probation. So it kind of takes away that that weighing yourself about whether or not satisfaction of the criminal sentence. So the board can weigh in the first option whether or not successfully completing the criminal sentence is rehabilitation, whereas the second option says that if they completed their criminal sentence, then that is rehabilitation. And then it takes away that second step of the board considering additional factors.
I'm going to have to go with option 1 again.
One of the comments that I wrote about option 2 is that, to me, it implies that completing criminal sentence or probation is equivalent to rehabilitation for a license, which I do not think is an appropriate connection to make. So I would lean more towards option 1.
Yeah, I would agree with Dr. Drummer. When I read option 2, I thought it sort of reduces it to a check in a box. And if you meet that criteria, then yeah, so.
Okay. Ms. McMillian? Yeah? Okay. Mr. Watkins? Okay.
And just kind of for the benefit of, the board and the public and OAL, kind of fleshing out maybe the point that Dr. Drummer made, or any other points that you might have about why 1 versus 2, or the point that was made is that rehabilitation and completing a criminal sentence is not equivalent. If we can,
So I have
understand that or flesh that out a little bit more.
I have a question about that idea as it pertains to option 2, because I also see kind of the opposite effect happening too, where the criminal history and the criminal probation, the sentence as a result of that history is still in effect, that would now not allow the board to consider any kind of rehabilitation or remediation that applicant might have, because they're still on criminal probation. Essentially, it means anybody who's on criminal probation could not be considered to have a license issued to them. And so it's the same discretionary issue. It's just in the opposite direction, and I have an issue with that as well.
So, Jason, you're saying that they would have to complete their criminal probation before they even be considered to practice, perhaps on a probationary license.
Correct.
Yeah, I'm not feeling that.
But if they had completed their criminal probation, you'd have to give them a license.
Also not in agreement
Not okay
with that either.
Right.
Double-edged sword.
Right. So then I guess it goes without saying that staff's recommendation is option 1 also.
Is that enough deliberation, Sala?
Well, I'm not sure that that's how I read it. So what you're saying is that if they haven't completed their sentence, then they can't be considered rehabilitation?
Within A only, right? And then B goes on further to state that if they haven't met A, then there's a whole new kind of scale that the board will have to consider
right.
because they haven't. So there's no, in one means that they've completed their criminal probation under option 2, boom, the board has to issue the license, which we've already identified. We may have a problem with that. And then if they haven't completed it, then we have to apply a whole different set of standards to that person because their criminal probation hasn't been completed. Where if we revert back to option 1, the discretion is just applied evenly amongst that applicant's circumstances on a case-by-case basis.
I mean, I see something similar happening in the 2 regulations, which is in the first regulation, it says that if they've successfully completed their criminal probation, the board considers whether that's constitutes rehabilitation, and if not, they move on to the Part B. And Part B has the same thing, though, is that if they haven't completed their criminal probation, then A is inapplicable, and you move on to
True.
to Part B, and you apply that criteria, right? I hope I'm not missing anything. So the option 1 and 2 appear to me similar in that sense. I think from at least the distinguishing feature that I see is just that A does that equating of rehabilitation and
it's
completing your criminal sentence.
It's going to be inferred or assumed that if they complete that criminal probationary period, that the board will be forced to consider that as rehabilitation.
Mm-hmm.
Yeah.
Board members still feeling option 1 is the best choice? Yep. So would the next step be to make sure that the language is what we want? As Sawa was reading through it, was there anything that jumped out at anyone?
I have a question about the showing of rehabilitation, and I'm wondering if it might be appropriate to insert a qualifier of the word sufficient. So the applicant made a showing of sufficient rehabilitation and is presently eligible for a license. Because to me, without that word sufficient, that somebody has showed rehabilitation and is eligible, that level of rehabilitation might be a little bit. It might, or, I mean, and not enough that we would say, no, you haven't done enough yet. You need to do more in order to get your license.
How would we determine what's sufficient?
We do that on every single case review that we do. We determine whether or not there's been sufficient rehabilitation in our deliberations. So it's our discussion and discretion, in my mind. It's an adjective, and I'm going back and forth as to whether or not. My first read of it was it needed it. Then
Yeah,
as I
now.
keep reading it, I'm like, I can live without it, but I'm wondering.
My concern goes back to the clarity issue. So when you add the word sufficient rehabilitation, it kind of takes away what you had, which is an on-off. They either are or they aren't rehabilitated for purposes of, getting their license or not having terms and conditions. And I guess when you put sufficient rehabilitation, it becomes debatable, like, are they partly rehabilitated, or how much rehabilitation do they have, as opposed to just the board doesn't feel that they're completely rehabilitated.
Right. And I can think of examples of when we have had petitioners come to us for decreasing their probation and wanting to be able to get their full license back. And we've heard their cases, and we've acknowledged them, and that they have made great strides towards what they need to do, but they haven't gotten there yet. We think that they need a little bit more. And so that's a case where I see our discussions, deliberations, and listening to what the petitioner has said, then we decide if there's been sufficient rehabilitation to decrease their probation
I think
or to reinstate their license.
I think since we're doing it already anyway, we don't need to add the word.
And I appreciate that.
You're
I'm
welcome.
good with that. I'm like I said,
Yeah.
my first read was, it needs something, and then reading it over and over, and I'm just wanting to hear what other people think about it too.
I like your comment, Dr. Drummer, because it makes evident that our mandate is at the front of your cerebral cortex.
Yours in particular.
And frontal lobe's all about emotion. And so,
And then just a note to address an issue stated previously. Any edit or change to this language that might be differentiated from any other package that's presented to OL at the same time may or may not trigger further scrutiny in the review. PSA completed.
So do any other board members see anything in the language that they're concerned about that they might want to visit?
And we are talking about option one still. Not a suggestion really, but a question. It's in reading, even in the prior section when we were discussing, seems like we decided to strike out severity and replace it with gravity.
And that is to conform with the actual language in 2138.
Great. So my question would be, under option one, B, and then sub one, the nature and severity of the acts. Do we want to change that to gravity, just to be consistent? My question.
That's
So-
pretty good.
In option one, let's see, if subdivision A is inapplicable, and then you go down to number one, the nature and severity of the acts. Do we want to say gravity there as well? Since under A sub one, we changed severity to gravity there.
Yes.
You are wanting to change it to nature and gravity?
Like it is above.
Just asking the question, because that's the term that was used, A sub one, up above it.
So B. I agree with that. Yeah, I would change it to gravity as well.
So I want to call your attention to what I'm looking at, just so that you can all look at it at the same time as me. I'm looking at section 493 in that build language, just so you can see what, and I'm sorry, I don't have the page. It's going to be past page 70. Or, yeah, that was what we were looking at.
PDF page 72. 493.
Yeah, the nature and gravity, the last sentence on the page.
Mm-hmm.
So everybody knows what we're looking at in the board meeting materials, page 72, I think is how it's going to be numbered.
Mm-hmm.
We're looking at section 493A of the bill, or the text. And,
The bottom is the
oh, that's,
bullet.
there it is, yeah. And it uses 493B1A, uses the language nature and gravity defense.
Great catch, Dr. Dominguez. And anything else board members see in the language?
I'd like to make a motion. I move to approve the proposed regulatory text of option 1 as amended
And can you list the
Yes.
specific amendments?
in, it's not numbered, subdivision B, number 1, the nature and gravity in place of severity. That was the only change we discussed, correct? For section 1399.21, direct staff to submit the text to the Director of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing. 0.22, thank you, Tanya.
I'll second that.
So we have a motion and a second, Ms. Ellaby and Mr. Watkins. And any further board discussion? Any public comment? Roll call vote, please.
Alicia Benet Amen.
Aye.
TJ Watkins.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Tanya McMillian.
Aye.
Motion carried, 6-0.
Okay. And the last one is going to be a revision of Regulation 1399.22, which is rehabilitation criteria for suspensions or revocations. And the memo for that will be on page, is that 80, I believe? Again, the memo does a great job of going through the background and laying out option 1 and option 2. I believe this one has a similar distinguishing feature of the previous one, except instead of being applied to applicants, essentially we're talking about licensees, suspensions, and revocations. So again, the first option requires the board as a primary consideration, if someone's been convicted of a crime, the board will consider, for purposes of rehabilitation, whether or not they've successfully completed their criminal sentence. And in making that determination, it lays out those factors 1 through 5. And it says, but if Part B says if the board doesn't believe there's been a showing of rehabilitation in considering the completion of the criminal sentence and those factors, then they shall consider those additional factors 1 through 7. Whereas option 2 says, takes away some of that discretion and says the board shall find that the licensee made a showing of rehabilitation and is presently eligible for a license if they've completed their criminal sentence, and says that only if Part A is inapplicable, then the board will apply this other criteria. So meaning, like in the scenario that Jason pointed out, if they haven't completed their criminal sentence, they're still on probation, then Part B would apply. Whereas in the first option, it can apply either way, whether or not they've finished their criminal sentence, if you don't believe that completing the criminal sentence equates to rehabilitation. And with that, I can answer any other questions you might have, or try.
Just same comment under section B, number 1. It also says nature and severity there. If we were to consider changing that to gravity.
Any board members feel strongly toward option 1 or 2?
Option 1.
Okay. Dr. Drummer?
Oh, yeah.
Oh, yeah. Okay, and so looking at the language, other than what Dr. Dominguez has pointed out for us, any other comments on the language before us?
I want to solicit the board's, help understand the board's thoughts on whether or not there's any perceived difference between the words gravity and severity. So I think consistency is another element that the Office of Administrative Law looks for. You want your language to be consistent and you want it to be clear. And so my understanding is that the reason for the change is that it promotes both of those things. But I just want to, solicit from the board, not advocating either way, whether or not the board perceives any difference, whether or not that makes it a different factor, or if it's essentially the same word, you're just making it more consistent or uniform.
I feel like they're synonymous in this context.
So the recommended change is purely for conformity with the statutory language.
Yes.
And in that internal consistency, I think that it does promote that internal consistency.
A quick search of definition of severity includes the word gravity
There you go.
as a synonym.
That will be in the ICE or no.
Let me Google that for you.
Grievousness, severeness, graveness, acuteness are also synonyms.
I don't disagree at all.
In the
But for conformity's sake, I would
Yes,
definitely.
when I think of severe, I think injury, weather. When I think of gravity, situation.
sure.
But they're synonymous as far. I just was pointing it out for consistency.
Early discussions in the language of the bill, severity was singled out as being having too much of a negative connotation, and so gravity was chosen for that reason. But I think to be able to apply weight to it, gravity is a perfect choice of words. You have to.
Okay,
Everything is about weight to me.
all right.
Depending on where you are.
If there are no other suggestions or comments on the language of option 1, does any member feel compelled to move?
I'd like to make another motion. I move to approve the proposed regulatory text for option 1 as amended by changing subsection B, item number 1, to nature and gravity of the acts or crimes. For section 1399.22, direct staff to submit the text to the Director of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all necessary steps to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing.
I second.
We have a motion by Ms. Ellaby and a second by Ms. McMillian. And is there any other board discussion? Any public comment? Okay, roll call vote, please.
Alicia Renee Amen.
Aye.
TJ Watkins.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer. Katarina Ellaby.
Aye.
Tanya McMillian.
Aye.
6-0, motion carried.
Thank you.
Before we leave this topic, I just wanted to say thank you, because that was 3 proposed language in the shortest period of time
Yes.
The
that
history
you as
of
a
the
group
physical
have
therapy
ever
board.
produced. And it's timely because of that time crunch. So staff thanks you very much.
Thank you, staff, for your work putting this together. Yes. And you're welcome.
All right, so as a result of the 3 proposals that you just approved, adopted as amended, we've already identified some things that need to be addressed in some of the open proposed languages, most particularly the model guidelines. So there are some edits that, as a result of 2138, will have to be considered. We provided some of those to you today, but we will be bringing them back to you for review as a package at the next board meeting to kind of go over it line by line like we normally would. But we have given you some of examples of what that looks like, both in the agenda materials and then as handouts today, where we're just really trying to address some of the language changes in 2138 so that they're incorporated in the already in process existing revision of the model guidelines. And then I will reserve, we may bring more than just this for model guidelines at the next meeting, depending on allowance of time and resources and that kind of thing. So we brought you candy.
Okay. And so we are at the point in the agenda where we can move and are ready to move into closed session. But before I do, I'd just like to offer one more time an opportunity for public comment on items not on the agenda.
Are we going to do the admin?
One more.
Oh, one more. I'm sorry. I'm ahead of myself. Is that agenda item 15? Yes. I'm sorry. Agenda item 15. Discussion of possible board action on the board member administrative manual.
Hello,
Hello.
I'm April Beauchamp, the Communication Education Analyst. And so if you would like, we can start on page 1 and go through it, or if you want to just talk about your reviews on it, or...
What would the board like?
Let's go page by page.
Yeah.
Okay. So it actually starts on page 7, after the table of contents.
I'm going to back you up. On the Acknowledgments page, which is, I believe, the third page that's in the booklet, PDF 93, at the very bottom, highlighted is May 2014. Is that highlighted just because it's something that needs to be changed, or because I've seen in other places where there are strikeouts and replacements? Is it intended that that date will change to a current date? As highlighted?
Yeah, the subtlety between strikeout or underline addition or highlight here is that the board, we do want to draw it to your attention that if you want to change the date of delegation, the board would have to adopt a new delegation for this. Right now, we're relying on the delegation that was approved at the May 2014. So it's an option.
Understood.
And was May 2014 the last time something like this was done?
Yes.
So,
We've relied on the same revision of the admin manual since then.
okay. I just want to make a comment on the acknowledgements. For members of the board, if this document is going to live possibly 5 years, I wonder if president and vice president can be listed as members and not necessarily as president and vice president. I don't know what.
I think it's a capture in time, and it's just a
It
matter
is.
of preference at that point. So, as an example, whatever the board moves forward with this today, we're just memorializing that that's who the president and vice president were
At the time.
at the time that this was done. But I understand what you're saying.
Because in 9 months that can change.
Absolutely.
And along that line, while memorializing that there is a vacant position, that's not a member of the board.
Correct.
So I would, if we're going to memorialize those members of the board, then I would just leave it as the 6 and not list vacant.
Could I also ask to add Ms. Ellaby's advanced degree on there? She does have a master's.
Thank you.
My pleasure. Well earned.
Thank you.
Okay.
Would the board like to, sometimes I've seen it this way and sometimes not, so that's why I'm throwing it out there, is to identify who is the professional members, who are the public members.
I think the PT after our name designates who are licensees. Is that what you're talking about? Okay.
And you are all public members.
Okay.
Okay.
My voice was really deep when I said that. It's really-
So we'll move on to page 7.
So, yep.
Are there any changes on this one? Okay, page 8.
April I'm looking at the second to last paragraph, second line where it lists political, personal, familiar, or financial. Is there a space in between or and financial, or is that just my eyes?
Oh, yes, there is a space.
There is? Okay.
Okay.
I actually would like to go back to page 7, which is PDF 97. In overview, about the middle of the paragraph, has been protecting the public from the incompetent, unprofessional, and criminal practice of physical therapy. Doesn't read well to me. And I'm wondering, incompetent, unprofessional, or criminal, I don't want to say criminal practice, something in the provision of physical therapy. To just separate those acts which are not part of physical therapy, but they may be occurring in the provision of physical therapy.
Do you have any proposed language that you can think of?
Protecting the public from the incompetent, unprofessional, and criminal acts in the provision of physical therapy.
Mm-hmm.
Because we're not intending to protect the public from unprofessional physical therapy or incompetent physical therapy. Because it's not that everything that a person might be doing is incompetent or unprofessional or criminal, but there are pieces of what they might be doing that is what we're identifying and what we're addressing.
Yeah.
The sentence after that, exists. I think it should say exist with an S. The board is one of over 40 regulatory entities which exists under the organizational structure.
Right, the board exists.
I'm channeling Deb right now.
Yeah, I think singular
Yeah.
one exists, whereas the 40 exist. But I think we're talking about the one.
The one, exactly.
Okay.
Could I just throw it out there?
Mm-hmm.
Actually, the sentence up above it has always been, so the charge has always been protecting. Could we change protecting to protect?
It's been to protect.
That's our charge, is to protect. What do we do? We protect.
Mm-hmm.
What are we doing? We're protecting.
Mm-hmm.
Anything else for that page? Hearing none.
I wanted to confirm in that last sentence, the board is primarily funded through license and application fees.
Mm-hmm.
And then it says the board doesn't receive any general fund allocations from the state.
Correct.
Just wanted to confirm that that's the case.
And the change to primarily funded through license and application fees is because there are other types of revenue that this board receives in cost recovery and those kind of things that can be a substantial source of revenue.
I have a quick question for Mr. Kaiser. So I think I heard the divine voice say, "We are all public members."
Mm-hmm.
So the paragraph
Say that one more time.
I can't. The board consists of 7 members, 4 licensed physical therapists, and 3 public members. Do we want to adjust that language to reflect what you just said, we're all public members?
I think that's very descriptive
Okay.
to the layperson. I just wanted to
Yep.
emphasize for those parties present that you
Thank you, sir.
Yeah.
I think that
it's in regulation.
Okay, page 8.
Moving on to 9.
Sorry.
It's 9.
I just said, actually, before we leave 8, gosh, probably halfway down that page, board members shall act fairly and in a nonpartisan, impartial, and unbiased manner. When I read that, I thought, just throwing out the suggestion there, does the word ethically come in here? Can you be fair and not ethical? I'm sorry. Partial bias. Yeah. Yeah, that's true.
I think to speak into the microphone so that the
I was saying that the sentence underneath it is repetitive, and maybe perhaps they could be combined in some way.
So the reason that they're separated there is just your day-to-day behaviors and how you do your work covered in the first sentence, but more specifically when treating applicants to the role of licensure, that impartiality and fairness is a must.
Okay, so on the first sentence, since we all did have to do the ethics training, I agree that should be stated.
I think ethically is
noted.
a good inclusion.
So how might that read, Dr. Dominguez?
Oh, I just threw it out there for discussion. I hadn't thought of where I would insert that word.
Fairly and ethically.
Or something to the effect of, will honor the code of ethics, something like that.
I think just adding ethically into that sentence, wherever you feel it's appropriate.
I want to point, I don't know if this has been seen, so I'm sorry if I'm being redundant, but that last paragraph there that points out ethical conduct. Not saying it can't be used more than once,
Sure.
I just wanted to flag it.
So could we just remove that sentence, since it basically says it in that last paragraph?
There's some weight in that first mention that's not included anywhere else, with the use of nonpartisan and unbiased. So if you were going to remove it, I'd want you to include those two descriptors somewhere else.
Then I would suggest moving it all down, moving those pieces into the final
Yeah.
point, because the final has a little more gravity.
Shall.
Shall is up above as well, but at the bottom of the page, it just implies a greater weight to that piece
Finality
and gravity.
and gravity. All that weight.
Giving it good support and strength at its base.
So do we need some verbiage?
I think what we would do is that first sentence, we would strike that first sentence, but we would take nonpartisan and unbiased and include it in the list of shalls on that last paragraph of the page.
Okay.
So it would read, all board members shall act in a nonpartisan and unbiased manner in accordance with their oath of office and shall conduct themselves in a courteous, professional, and ethical manner at all times.
So I would place it later in the sentence. So it would still read, all board members shall act in accordance with their oath of office and shall conduct themselves in a courteous, professional, nonpartisan, unbiased, and ethical manner at all times, or any combination of thereof of that sequence.
Okay.
Okay, page 9.
Page 10.
Page 11. Page 12. Page 13.
Well, going back, sorry, I don't want you guys to speed along with me still back at 10. So page 10, it has the citation to Government Code Section 11125, and it says etsec, like a sequence. I just wanted to double check if that was actually etsec or is that a direct citation? For example, is notice of meetings completely addressed in that section? It looks like it is. So was something else intended by using etsec there, or should that be removed?
No, I believe it stays.
I guess what I'm asking is I think that paragraph regarding notice is completely addressed by Government Code Section 1125 as opposed to a sequence of provisions.
Okay, so we would remove etsec.
That's what I would recommend. So if you go to that series of statutes in the Government Code, I'm looking at 11125, and that's just relates to notice of meetings, which identifies the 10 days advance notice. And then if you were to do etsec, which means a citation to all following provisions, the next one would pertain to agendas and other writings. Appointment, employment, dismissal of public employees, action on items of business not appearing on the agenda, special meetings, emergency meetings, Fish and Game Commission. So are there any other section codes you were intending to cite for this paragraph, or is it just 11125?
There's no other intended codes. That set could be stricken.
Okay, yeah, I can't go through, compare that whole
Yeah.
paragraph's language right now, but it looks to me it's just 11125.
Any other comments on 10 or changes? And 11?
I think I might have the same comment for the previous notice, because it actually has that citation twice on page 10. It has notice of meetings, and then it says 11125 at SEC, and then it says notice of meetings to be posted on the internet, and then it will have the same citation.
Yes, that should be stricken out too.
So it should be just cited once for the both paragraphs. I think that would be my recommendation.
Okay. Yeah. Okay. 11.
All right, I'm on page, I think it's 11, page 11. And there's that paragraph regarding minutes. And I think a statutory reference is removed, 6254A.
Yes. When this went through with Anthony, he said that was incorrect, so
Yeah,
I was going to assist in finding the correct statute.
Yeah, I think it looks to me like you're looking for the correct statute. And so that's what I'm trying to fill in since that hasn't been addressed. So try and get that for you. I think it might be the board and each committee or task force shall keep an official record of their proceedings. The minutes are a summary, not a transcript. Minutes are addressed in 11125.5D. That relates to special meetings or emergency meetings only. So I'm also trying to find the provision for regular meetings. It may be, well, never mind. 11124 is in relation to sign-in sheets. Minutes are also required in Oh, that's only in relation to the Gambling Control Commission. That's the one I can find right now. So I would include 11125.5D
Thank you.
as a citation.
Any other edits on page 11?
I have a question about the section on electronic recording. It says that all electronic recordings, essentially says that all electronic recordings need to be erased or destroyed 30 days after. But we are being live streamed and potentially recorded throughout the universe.
Yeah, and that's certainly a remnant of previous direction. And given new technology, that's definitely something that you would want to consider. It's a very broad requirement to fulfill, too, because once it's been broadcast once, it can be duplicated, and there would be some obligation to make sure that it was removed anywhere else. It's not applicable any longer. I'd have to look at that statute to see if that's been addressed recently. And it is a maybe.
Well, it may be recorded.
11.
But may be erased or
Oh, the
destroyed 30
minutes.
days after the recording.
Board minutes. 11. Thank you.
It may be erased or destroyed. I would see that. That's
As
where
a choice.
that's where the may be
The may is the
erased
difference
or
between
it
the
may
two?
be destroyed within 30 days. Not that you can erase it or,
Yeah, it's
or
not.
not.
May or may not be destroyed.
Permissive in the sense, choose one or the other.
Exactly. Yeah.
So what do we do with that?
It is a maybe. Just leave it.
Well, the meeting may be recorded. The second paragraph to me reads that if it is recorded, any audio or video recording may be erased or destroyed. Those are the options. It's not you can do whatever you want, or you can erase it or destroy it. It gives, because of the time frame, it has to be, in my mind, it has to be erased or destroyed within 30 days.
I get that.
Not that you can, if you want to
Yeah,
erase it or get rid of it, you
exactly.
can. But because we're broadcasting, I'm wondering about whether or not this is actually applicable anymore.
Right, it's obsolete, basically.
I read it differently, but it's a direct quote from that statute, and the statute's still in effect. And essentially, the way I see it is, there is a may, like, you can or cannot provide an audio or video recording.
Mm-hmm.
And then if you do, you're obliged to at least keep hold of that for 30 days, and then after that 30 days, you may erase or destroy. But again, it's a matter of sequence and sentencing that creates the confusion.
What was the spirit when this was written?
Given the technology at the time, I'm sure it had to do with space and server and like how many tapes you kept lying around, and as far as retention goes, because at some point you've already recorded minutes, and the minutes are supposed to be a summary review of the actions that occurred.
So this this subheading, electronic recording, in paren says board policy. So can we have a sentence about our board policy and not cite the code? Is that allowable, or Is that something we would consider?
Even the policy is different now, potentially.
Right.
And again, the electronic recording that was happening at the time was an audio recording on a cassette tape.
You're right.
And the cassette tapes were being, destroyed once the minutes were created and adopted. That's why it references the retention schedule.
Who creates board policy?
The board.
So when's the time to do this? In June? Because it seems like, I don't know.
It's existing policy now.
Right.
It's whether or not you want to propose a change or not.
Can we do that today? Because it looks like it needs to be changed. Any other board member comment on this? Just eating candy?
So as it's agendized today, it's for discussion and possible board action on the administrative manual. So if you wanted to change policies contained within the manual, I believe that it's agendized properly and that you could.
The meeting may be electronically recorded, whether by video or audio.
That still works.
Take everything else off.
Yeah.
Because as soon as we put something else on, it's going to change in 5 years.
That's the way technology works.
Do you mean delete that second sentence plus the following paragraph?
Yes. Because we're not going to dispose of the electronic recordings. And we're not going to destroy or erase them 30 days after the recording. So just as a board policy, keeping it straightforward, simple.
Well, I think that would be deleting a lot more than just how it's retained or how it's disposed, because you'd be deleting the information regarding the Public Records Act, and how it would be provided without charge. So there are very multiple policies happening here other than its retention. And then it also, while the board doesn't currently, I guess, erase it after 30 days, the second sentence there seems a little more flexible. It says it will be kept according to whatever the retention schedule is, which I think does exist.
I think the potential to change the policy is fine, right? Removing, electronic recordings will be disposed of upon approval of the minutes. You could delete that sentence. I think you have to leave the citation to the government code, specifically for what Sal was stating, is that information regarding the California Public Records Act still applies. And those recordings would have to be made available upon request by an outside party for that 30-day period at a minimum. It's kind of inconsequential for us because with YouTube and the way we're doing it and using it as an archive, it's going to be up for an undetermined amount of time, but well in excess of those 30 days that's required in the government code.
So then the second paragraph couldn't be changed at all?
I would leave it.
Okay.
And leaving it, I don't think you really change anything
Yeah.
given today's setting.
So we're just deleting the second sentence of that section. That reads, electronic recordings will be disposed of upon approval of the minutes in accordance with the board's record retention schedule.
Correct.
I support that.
deleting that second sentence but not impacting the second paragraph.
Correct.
Leaving the second paragraph in total.
And for that sentence, I'm sorry if I missed it. I found another section code for the minutes though, but is it not impacted by the board's retention schedule or does it not, the retention schedule not address it?
It's not, and that's more having to do with changes in technology and that kind of thing, and utilizing YouTube as the webcast provider, that electronic recording is made available well outside of the retention schedule. So for us to say electronic recordings will be disposed of upon approval of the minutes isn't really accurate anymore.
I see. For the minutes section, right up preceding that, I'd cited 11125.5D. I'd also recommend citing 11126.1. That one relates to closed session minutes.
Thank you.
Do we need to take action on that board policy, or is that living somewhere else, not just
No,
here?
it's if just so in the sense that if you're going to, as a board, in agreement, approve of deleting that second sentence, we would use that as the adoption of the board manual as amended.
Okay. Okay.
And it sounds like everybody is wanting it to reflect actual practice. So.
Unless you have a box full of cassette tapes that we need to erase or
Destroy as a result of the retention schedule.
Anything else on 11? Okay, page 12.
Under 2A, where it's the second sentence where it says, the board may designate either its executive officer or a board employee. Can we do that? Not that I want to, but is that correct?
I guess if the EO wasn't available and an AEO
Yeah,
was.
absolutely.
Yeah.
And it may be particular to that particular unit. If it's an error involved in the application process, the application manager would be the employee that the board would designate to find out what that error was.
Okay.
Anything else on page 12? Okay, page 13.
April, I have a question about the travel arrangements section. I believe when I first started with the board, we were booking our own flights, but now it seems like everything goes through the board liaison. So maybe we should update this to reflect that sort of internal process change. If this might be used as an onboarding tool for future board members, it should be clear that they should connect with you or whoever replaces Araceli for their travel arrangements.
On that thought, I'm wondering if maybe we should just change the word should to may.
Mm-hmm. Okay. Thank you, Dr. Drummer.
You're quite welcome, Ms. Hellerby.
And also include at the end of the sentence, whatever else, flights or transportation. It's not just lodging.
Change lodging to travel accommodations?
Yeah.
Anything else on page 13?
Yeah, for the DCA travel guide, I think it might be important to indicate, you know, what version you're referencing. I think what I've been able to find, I believe the current version is May 2018. Just so that you know what the board was looking at the time they adopted the manual, because policies and guides could change.
I know.
Without the specific citation, to me, it would imply that the president would need to follow the current travel guide.
And I don't know how long the travel guide's been around, but I agree with you. I think that so long as there is a more current guide, maybe that can be clarified, the most current DCA travel guide perhaps. But I'm just thinking like far into the future, and maybe there isn't a travel guide, and someone's trying to find whatever it was the board was referencing. But I guess what you could do in that situation is look
Bring
at
it
when
back.
you can bring it back,
Yeah.
or you can also look at, I guess, the amendment date and see what was the most recent since that time.
Right.
But I just know that when we were looking back and trying to find all of these policies,
That's
and
the issue
things,
that I'm trying to avoid, is that some of
Can't
the
find what-
corrections that we've made here are because policies have changed. They've disappeared through archive or what have you. But so I would like the most flexible language in the sense that whatever, DCA travel guide is available at the time. And if we did run into a situation where it was no longer called the DCA travel guide, we could always bring it back and have the admin manual amended to account for it.
Yeah, I would not want us to say the 2019 DCA travel guide and then have it change
you're using-
at the end of the year.
But I
And
do
so-
like most recent.
And it becomes, yeah.
Can someone help me understand what that paragraph or that sentence means? The board president's approval is required for all board members' travel, except for travel to regularly scheduled board, committee, or task force meetings to which the board member is assigned.
So you don't necessarily have to approve travel, as an example, for today's meeting. The nature of the business is given, but if there is a special meeting or a gathering of some kind that the committee formed underneath the board is going to travel for, you'd have a yay or nay vote on whether they could or couldn't, or even amend that travel for fiscal reasons. But for coming here, you don't necessarily have to intervene. That's a given.
But even committee and task force meetings, except for, those aren't included either.
Regularly scheduled committee and task force
Okay.
meetings.
Yeah.
Okay.
But, oh no, I can't go to meet with Governor Newsom. Ms. Ellerby, I need you to go.
Okay.
I'm authorizing your travel to fly up and to stay overnight,
Okay, thank you.
No problem, I'm happy to go.
as an example.
That helps.
So I just had the producer was speaking into the mic in my ear. And we need to take a small intermission, a break, stretch your legs.
Our closed captioner offsite needs a break.
Okay. It is 2:59. Let's come back. How long of a break does your closed captioner need? Probably 15 minutes.
I would say.
Yeah.
I'm not sure that if I can get back to you on that.
Okay. Let's come back at 3:15. Time is 3:15 and we're back on record, and we have been discussing agenda item number 15, which is the administrative manual. And it is a tedious task. It's taking some time. So I would like to propose that we take this up at our next board meeting when all board members and legal counsel has an opportunity to really review the document and make our notes and our comments and questions and bring it back, so that we're not taking page by page and spending a lot of time on this during the meeting itself.
Second.
Okay.
Point of clarity, Alicia, when we revisit this at the June meeting, we're going to pick up where we left off, not start from the beginning, correct?
That would be great.
Wonderful.
That would be great.
Just one more point of clarity. The intent of this review also is to update this manual from or subsequent to the next meeting. From that point moving on, once we collect 2 or 3, maybe 4 changes that we think are required in the admin manual, we will be bringing it back to the board on a more frequent basis for that revision. Right now, it's not too much of a hurry. We've operated under this admin manual for quite some time, and while the references are outdated, the content is still usable and we can still follow it, but we'd like to maintain that better. So at the next meeting, if there's anything between now and then that you find in your review, if you could be prepared to discuss that at the next meeting, we could go through it much more quickly.
Mm-hmm. Yes. Okay, sound okay with you, April? And is there any public comment? Yes, come on up.
This one, okay.
Testing.
David Campbell, licensed PT, Oakland. I realize we're trying to move on from this, so I'll be brief. Page 7, the introduction. So I realize regulatory languages, I think, intends to protect from a floor rather than being aspirational towards a ceiling. I'm wondering if it might be worth considering language that would combine the two. So, for example, I'm thinking, so paragraph 2, line 5, the charge to the board by the legislature mandates the ethical, competent, professional practice of physical therapy, thereby protecting the public from the criminal practice thereof. Something along those lines is that a reasonable question or consideration, or is that sort of does that shift the emphasis from where the regulatory intent needs to be?
I like it. Any comments?
Can you repeat it one more time?
So I understand that regulatory language is usually oriented towards protecting from a floor rather than being sort of aspirational towards a ceiling. I'm wondering if, rather than being framed in terms of strict protection from unethical and incompetent and criminal, if it could be a little more aspirational towards mandating the practice of ethical and competent physical therapy, thereby protecting the public from adverse effects or the criminal practice thereof. Something along those lines.
This sentence is about the charge to the board, not the mandates on the public's responsibility. So the charge to the board is to protect the public. Looking at Business and Professions Code section 2602.1 relates to the priority of the board to protect the public. I don't know if the recommendation is to change it to say that the charge to the board by the legislature mandates protecting the public from the incompetent professional and criminal practice. If that's the recommendation, I don't think that language is necessarily consistent with 2602.1, which just says that it shall be the highest priority of the board.
And I'm not suggesting or recommending anything really other than just, is it maybe worth consideration at the next meeting, something to keep in mind. And I realize we're trying to move on from this, so that was just my only comment.
Having another cerebral cortex in the room is a good thing.
Hey.
So I think maybe just if we can all kind of put an asterisk near this sentence so that as we're reviewing it before we meet again in June, that we'll all take another look at it and, come together and see if we can take that consideration, some of that language in there. Yeah, thank you.
Thank you.
Thank you. It's
Yeah.
been very informative, educational, and enlightening.
Okay. Thank you, April.
Thank you.
Okay, so did I hit all the agenda items? I think we're ready now for a closed session. Yes? And so it's 3:22. We're going to move into closed session and then open up to adjourn or recess until tomorrow morning. So, is that right? Yep, recess until tomorrow morning. Okay, thank you.